now the picture in the UK. We heard also a few very interesting statements by Sir Richard. Afterwards, we heard, how things are dealt with in continental Europe, especially at the UPC, and in what sense the UPC helps us to overcome licensing issues, SEP licensing issues. And now we want to wrap up, because it's the last session, and take things forward and reflect a bit on what the differences in the approach mean for international disputes on the one hand, because we know that SEP disputes are very often international, and they are taking place before different jurisdictions. And Sir Richard said it, that there's also a bit of what economists would call forum shopping involved here, and strategic moves. And secondly, we want to reflect on what this means for the SEP regulation. And we have a wonderful panel to do that here. Many of the faces you have seen already, so I will not reintroduce the excellent speakers that we have on this panel. There's just 2 new faces, so let me quickly introduce them. So the first one is Nina Belbl. She's from WIPO with us today, so that's fantastic. She's legal officer there, and she works in the Patent and Technology Law Division there. And as you would expect, her main work right now is, of course, with the implementation of the WIPO SEP strategy. So perfect match, I would say. And the second new face that we have is Taraneh Maghame. And Taraneh is an internationally recognized IP lawyer. And she's also former member of the European Commission's SEP expert group that we have heard already a few times coming up today. And what's also very interesting is that she has worked with a couple of firms, both on the pool side with via licensing, and also for a few implementers, so we can leverage her knowledge and from both sides of the market. Now that said, let us directly jump into our discussion. And one theme which is interesting is that Sir Richard said that he is not aware of a continental European court that has done franc determination. I would not start to disagree with Sir Richard, of course. But one question that I have is whether, although there was no franc determination, maybe, let's see, whether the German courts have advanced in franc assessment more generally. And one case that comes up here is the IDC Lenovo case that we heard already in the UK, and we heard already that in the UK there was done a full-blown franc determination. And what is interesting is that there was a sequel to that case, and that sequel was about what should be done actually once the license that was determined by the UK court until the end of 23, if that expired, what would be the rates and what should happen thereafter. And that case was dealt with before the Munich District Court. And Judge Pichlmaier since he's presiding the Munich District Court, I would have a few questions on that judgment, if that works for you. And I mean, maybe to just segue into it, how would you describe the franc assessment in that case? Is that something that we should keep in mind?
Thank you for this question. So first of all, it's not my judgment. So I also can talk about, and I have it in front of me. And if the question is, if this judgment is a full-blown franc assessment by a German court, I can clearly answer this question with no, it is not. Why? In this judgment, the court has some explanations to franc and what is the basis and so on. And then it comes to a kind of an assessment. But the assessment is just referring to what the UK court said. And the franc rate, they said. The Munich court says, let's have a look if this is convincing for us. And the answer is no, it's not. It's not convincing. And that's not a franc assessment for me. As Judge Arnold said, come to the point, and the point is how much. And the question is not which amount is not franc. The question is which amount is franc, in what scope we are talking about franc, and not. It's not that interesting which figures are not franc. So in my view, this is not a full-blown franc assessment. But it's. Don't understand me wrong, it's not a criticism of this judgment, what I say. You have to keep in mind, and that's a big difference between what happens at the UK courts and the German courts, you have to keep in mind what is claimed. You know, you just can judge upon what is claimed. And in this German suit case, there was no franc setting claimed. Also, this is possible from a legal point of view. That's my opinion. It would have been possible, but that's not what happened. So that's just a franc defense. And maybe that's the explanation why this court doesn't go that deep inside this economic question, what is the right price and how much is it. In contrary, the UK court, there is claimed a franc setting, so they have to find an amount, which is franc, and that's the big difference. And let me add this, the question also for the UPC will be, what can we do as the UPC? Is also, as for the German courts, is it possible to make a franc setting, yes or no? And what I think is, yes, this is possible. It is said as a counterclaim concerning licenses, that's very broad in this expression, is possible. So as we as a UPC have to find out what does this mean. What can we do? I think franc setting is possible on this basis. And just the question is, are we bound to what is exactly claimed by the defendant, or do we have some room for maneuver for what boundaries are existing? We will find out this. And at the end, it could be that also if there is a special amount claimed by the defendant, we can go even higher, because that's not, we are not bound by this amount. That's something which is not in favor of the defendant. So it's a minus in my view, and we can judge also a higher amount if it is not claimed. So we have room for maneuver in this point, and just we need this. These cases where this is claimed, like in the UK, and then we will see and can see what is possible at the UPC.
Yeah, yeah. What is remarkable with that judgment actually is that there are dozens of judgments in Germany where implementers are found to have not responded in the right time, not long enough, asked too much, and so on and so forth. So that judgment goes a bit into valuation, into first assessing the offer and then assessing also the level of the counter offer. Would you say that there was as we understand, I mean that is also the reason why the Commission intervened. There is of course the question whether the counter offer can be assessed before the offer, or whether that should be done in the Huawei ZTE sequence. Would you say that in that judgment the order was as pretty standard as it should be, Huawei ZTE, first the offer, then the counter offer, or?
As Matthias Zigann said, I think you have to have a look at not just to one of the steps, maybe just one email written by the defendant. As you have to see the whole talks between the parties, what happened, and what offers were made by the one side and by the other, and then you can assess in which way the one party behaved or the other, with the background of what is claimed in your case. That's for sure. But just to this very technocratic approach to first to have a look to the offer and then to the counter offer. You have to make a picture of everything what happened, I think.
Yeah.
That's it.
Going from procedure to substance. What is interesting in the UK courts, in the UK decisions, I mean, of course, UK courts are aware that there is a franc range, but then they are determining, a franc rate, because they need a rate in the end, one single value. Now, what is publicly known is that Lenovo offered the very same rate that was determined by the UK courts in the counteroffer. So that is, of course, something that has an appeal, because the UK court is, an objective body, and yet it was found to be non-franc. And one of the reasons was that one should have done an adjustment for inflation of at least 30%, which is remarkable. Now, question: given that the franc rate that is determined by UK court is, somewhere in between the franc corridor, how could the Munich court find out that, the offer, which was the rate in between the corridor, is still too low, is below the corridor once you, take into account the need for an inflation assessment? I mean, that's very sophisticated.
Yes, but I personally think it's not such a bad argument to say we are talking about, I don't know, at least 10 or 20 years, I'm not sure, at least 10 years, and nothing changed in this time. It's always the same rate. And the question of the Munich court is this convincing? And the answer from the court is no, because we had a lot of inflation in this time, so something should have happened with the rate. It's not something which is just without any movement. And so for me, that's a point which is not that, it's not that bad as an argument to say why is there no movement in the rate? Why is it just this, every time the same rate? Is this really correct?
Okay. Let us maybe then move to the UPC, and you mentioned already that you're hopeful that at the UPC we might have more of a scope for front determination also with the counterclaims. So I think that's an interesting point to park and come back to. But before we go there, let us quickly pick up again the Huawei Netgear decision that Judge Zigann was working on, or was presiding even. So what we want to do now is we want to compare a bit the substantive criteria that are applied in that judgment. We know already that in terms of framework, there are differences between UK courts and the UPC, and Judge Zigann explained to us already that there are, of course, boundaries to what the UPC can and cannot do. But let's have a look at a few substantive criteria. What is interesting is that ultimately you compared, what you said is that there would have been the option for Netgear to enter into a pool rate, of the Sysvel pool, and there was the argument by Netgear that they were discriminated against because potentially there are some other licensees that get a much lower rate by Huawei, which is something the UK courts are very, very careful about. And if they had to pay a higher rate, and even if it's the Sysvel rate, then they might be discriminated against. It seems that this was a claim that you did not find very convincing. Can you help us understand why not? Licenses that are comparable, and meaning entered into by licensees that are in a comparable situation, comparable size, for example. Now, this brings us back to the discussion that we heard early on in the morning. Like this single license that you mentioned, Judge Zigann, in the end led to to the 22 cent on appeal. Now, we know that we heard it this morning actually, that there are, of course, licenses where 69 cents are paid. Now, if we are taking these licenses into account, even for large players, does what you just said, does it mean that large players should be held against licenses of small players such as Fairphone? Conscious of having, artful pleading, so that, the UPC can do its power. That brings us to Taraneh. Taraneh, like the very same case actually, Huawei Netgear, right? They settled later, actually earlier this year, after the injunction came down. I mentioned in the introduction that you've seen a lot of licensing negotiations. Give us your picture from inside the machine room. What happens after an injunction is awarded, and what would you imagine? How did these negotiations go after this injunction was issued?
Well, after an injunction issues, the balance of power certainly shifts quite a bit. If you have a company whose products are being taken off the market, there really is not, unless you're willing to withdraw from that market. For example, we've seen some Chinese companies be willing to do that from when they were issued injunctions in Germany, then you really need to sit down and try to work out a deal to avoid that injunction. So I think that at that point, it becomes a different dynamic. We don't know what the terms of that settlement are, obviously, but this is why the court cases are so significant. This is why injunctions are so significant, because it does dramatically change that dynamic. If an injunction is not issued and there's a FRAND rate, then the parties can choose to either accept it or not accept it. But with an injunction, you kind of don't have that option, right? So the question then becomes, do you sit down and do the bilateral, or do you take a pool license? And in that situation, I think it was more directed towards a pool license. So what ended up being at the end, I don't know. Having actually managed pools for years myself, I know that the rate that would be paid into the pool doesn't even really tell you what Huawei's rate is, because at that point, everything that happens after the payment is made to the pool is pretty much behind a wall. So the distribution of that money to the licensors in that pool is an unknown to the outsiders. So that also makes it even more difficult for that license to potentially be used as a comparable in the future, because for a particular party, because the distribution of the payments is unknown.
Yeah. Let us shift the perspective now a second. So, we heard that it's quite difficult to negotiate. Like once the injunction has been issued, it's a bit like having a gun to the head. We heard also Sir Richard, being concerned about Panasonic in the Panasonic case, and about like it was labeled even in the judgment as an conduct of an unwilling licensor if one first accepts FRAND determination by the UK court, and then at the same time seeks to obtain injunctions in continental European courts. Now, having heard these concerns, Judge Pichlmaier, is that something that resonates? Is that something we need to take seriously in continental Europe, or is that just the UK perspective?
I've heard the nice word committee in this context, also from Mr. Judge Arnold, and that's interesting because usually we just, as I said, judge upon what is in the case. And if it's about an injunction, we make an assessment if we have to injunct the defendant or not. Yeah, that's our job, I would say. Usually you don't think about if you are in the scope of your, for example, at a national German court, you just make a judgment for Germany. Yeah. So in this moment you don't think about if this could be any problem for the colleagues in the UK, because we are not make a judgment for in this context directly given an impact to the UK courts. So I see that could be a problem for the UK courts because it's disturbing their case maybe and their proceedings, but it's not an unfriendly act, I would say. What we are doing, it's in the scope of our what is in our law. It doesn't matter if it is the UPC or a national court, and as long as we don't give an impact, a direct impact to another jurisprudence, I think for me, personally spoken, there is no problem in doing so.
Yes, right. So this means basically that we have the UK rate, and the fact that an injunction in Germany could be used to extract a higher rate than what is determined by the UK is something that from a German perspective one needs to see agnostically, right? There's little one can do about it.
Right, and I see the concerns. On the other side, we will see what the UPC will do with rate setting, and then we maybe have the same problem the other way around, because it's kind of a greyhound race then, who is first make the rate, I'm not sure if this is the development we want to have.
Okay, yeah, understood. Let us now move on to the counterclaim again and to Judge Zigann's invitation for actions for counterclaims. Now, and it's possibly interesting to hear both of your perspective on that. I understood earlier that in the end on the counterclaim it's not really about FRA determination because one has to go in with a claim with an amount. Would you concur with that view, Judge Pichlmaier? Just to be sure that I understood you correctly.
As I said, so the wording of the UPCA in this context is very broad. It's I repeat it. It's a counterclaim concerning licenses. We will see what is meant by this, and we will know what is meant by this if the Court of Appeal has made a judgment upon this question. So long, I would say it's very broad, and we can do a lot as judges. There is room for us for rate setting, like it is done in the UK, I would say. So, if you have a court which is that new, like than the UPC, we have to try out some things, and then we will see what is the right way to proceed. But just from the wording, it's very broad.
Yeah, understood.
I would like to add that, of course, you need helpful prayers by the defendant.
Understood.
But of course, the court is free to kind of stipulate to the filing of new prayers if the prayers filed in the first place are not so useful.
Yeah. And we went a bit into the difficulties that the UPC is facing also with the limited mandate and the framework that is a bit more rigid than in the UK. We heard also in the SEP regulation panel earlier on your perspective, Judge Pichlmaier, on the potential interplay between FRA conciliation and then how it's used in a German court. There you adopted a bit the German perspective. Now, just quick confirmation, would the same also work from a UPC perspective? Would that facilitate things to have then like a conciliated rate as an input to these counterclaims? I mean, one could even imagine that like the implementer comes with a conciliated rate and uses that for the counterclaim.
So you mean if you have a setting from a UK court?
What I mean is, like, I understood, Dr. Zigann, that we need a rate to start the counterclaim.
Yeah.
Right? So we need some value.
Yeah.
Now, it's of course not easy if one offers too much. Then, well, good luck for the SEP holder. If one offers not enough, then bad luck for the implementer. One idea could be that one does the front conciliation first. Then one gets a value, a front rate, and uses that as the claim for the counterclaim, right? I mean, for me, that has some appeal because one has an objective body that comes up with a rate that is then used in litigation. Do you have any thoughts on that? I mean, very spontaneously.
Yeah, why not? I think that could be the sense, and it is. We have similar proceedings in other fields of law in Germany to have some kind of conciliations. And what is found out there, even if the parties not agree on this rate, is a basis for the court, who then has to decide. So it's not for nothing, this conciliation.
Yeah.
Maybe it's not agreed by the parties or by one of the parties, but that's a good basis. To go on with the judgment and with the proceedings.
Wonderful. Okay, good to know. So we have some complementarity here. So Nina, you were very patient so far, so thank you for that. We have this, it's of course very important, to put into perspective the different tools that we have to solve these international FRA disputes. What can the WIPO add to those tools, to this toolbox?
Yeah, thank you, Benno. And also, it was very interesting to listen. As a former litigator in Germany, I'm always very happy to listen to the judges, and so no problem with my patience. But coming to WIPO, of course, if you talk about the actual dispute resolution, we have our WIPO Arbitration Mediation Center that has been solving or offering means to parties to solve matters in this venue. And they have been doing this for quite a long time, also before the SEP strategy. So this is something a bit aside that we include, of course, but that has a longer history. And so far I can say that they have around 80 cases. Mediation, there would be a possibility for friend expert, so expert determination, which could also be, of course, used to determine a rate. As far as the colleagues told me, that has not, there were some ideas floating around from some parties, but that has not been done yet. So it's mainly, or uniquely, mediation cases. So, and if that is of interest for the audience, I'm very happy also to refer to the details to my colleagues, because obviously I'm not only in the I'm not in the center, but you invited me more for the more global perspectives of WIPO. And here, as you mentioned, we have launched our SEP strategy. For those who are interested and haven't read it yet, it's also available online, so I won't go into detail there, but maybe just to put it into perspective. So for us, of course, it's a very different approach than for any national or regional regulation. So we just by nature are in a different organization than any body that can initiate a regulatory initiative. It's just because in our setting, a UN agency is always member state driven. So if in our standing committee on the law of patents, there are treaties technically discussed, could be discussed, but this is not our initiative, but a member state initiative. So if member states think in the phase of, and that is not only concerning, that's a very broad scope, that one needs to streamline certain rules, then that would be the area to do so. I think I can say that it's a very difficult negotiation there for the member states. I mean, it's 193 member states, so the treaties that come out of these kind of committees have been negotiated for a very long time. I think the last one was about 20 years negotiation. So technically, if ever, this would be the place where WIPO would, or where the member states would technically can agree on these kind of rules. But this is very much apart, because in our standing committee there are SEP matters discussed, but so far the member states, very recently Canada brought it in, member states are focusing on sharing knowledge and compiling, and WIPO is assisting them in that regard. So just to make this differentiation. And so a part of that, we have the strategy, which is focused on complementing basically the actual, the market, what we see and what we hear from stakeholders that might be helpful that we can do. And one area and is surely the global dialogue area. I mean, we have heard from several judges that it's interesting also to interact between each other. And there we have the Judicial Institute that offers a very safe place for judges to, without any basically between them, to really interact, and there are also SEPs discussed, for example. And just to also mention that, and this is something that we hope you all have your agendas here, because we will also convene an event in September 18th, 19th in Geneva, which will be the first purely WIPO SEP event. We did one with the EUI last December to start, but this will be a bigger event. And of course, I mean, we have not yet any concrete program, but we would aim for very different areas, and also different approaches, in the sense that we think, for example, certain workshops might be helpful under Chatham House rules, just to give also stakeholders the possibility to discuss more freely, and maybe we can, in that sense, help the certain discussions that stakeholders see important and want to discuss. And others is, of course, we launched. I know. I come to the end. No worries. And maybe just to also flag that for the WIPO Lex SEP case law collection that's was launched recently. We have added the UPC, and here one can just check free of charge certain case law, and we will also come up with studies. And another project that I'm really looking forward to and is currently under development and will be launched soon is the project that our colleagues from the patent scope data scientists work together with STOs, and we will basically link the data on our patent scope that many of you will surely know.
Right. So, like in summary, there's lots of guidance that you can provide, and there might be something, you know, some even going into some global solution in the very, very long run, right? So as I understand,
well, as I
that's
said,
at least possible. It's not.
As I said, this would depend on the member states. So,
exactly.
So that's not up to us.
Absolutely, no, that is understood. So that is, you know, very, very long run. But in the short run, this means that, you know, you would require consensual mediation and arbitration. It's like if there's no consensus to come to you, then we need to go back to the courts actually and see what we can do if there are disputes that cannot be solved by means of arbitration or mediation.
Just to maybe also add, the routes to come to the WIPO Arbitration Mediation Center are very different. So technically also we have seen cases where judges, depending of course on the procedural rules of the jurisdiction, refer in a case to the Arbitration Mediation Center for mediation.
Yes.
So it does not necessarily to be the initiative of two parties.
Understood. With the consent of the parties, of course, because I mean, in the end, they need to agree. Now, this brings us back to the disputes that, you know, cannot be solved by means of arbitration. And Taraneh now, and I understand that people are getting thirsty, and the drinks are waiting outside. And we started a few minutes late, so I hope that please bear with me that we can do this, you know, very small ping pong. So. Going back to the disputes, Taraneh, what we've seen is now a few international disputes that have, you know, very, very similar patterns coming out of those disputes. And like one is very recently ZTE versus Lenovo. Then we had also the Panasonic, Xiaomi, and so on and so forth. And there was always the European courts, UPC involved, also the UK courts. Very recently, ZTE versus Lenovo, it looks like that basically implementers are trying to be quick in the UK courts, while SEP holders are quick to bring infringement actions here in Europe. Can you make sense of that? Can you help us making sense of that pattern?
Yeah, I can answer that in 8 words, but I'd like to expand on that.
Oh, please, 8 words is perfect.
You know, everyone's looking for a way to resolve this dispute. Nobody's saying, we don't want to resolve it, we don't want to have a deal. I think each of these parties wants to get a deal done. The question is, how is that deal going to get done? When you see implementers going to UK courts, what are they asking for? They're asking for a FRAND rate to be determined. We don't see the German courts doing that. We don't see the UPC doing that. Therefore, where are they available to do that? The UK courts. That's why you see them going to UK courts. The SEP holder, as you asked me, the one question you've asked me so far, what happens when an injunction is issued? That puts the SEP holder in a position where they've got pretty much a gun to the head of the implementer saying, you have to settle on terms that I'm dictating at that point to some extent, right? What are they going to do? Go back to court, the same court, and ask for a FRAND determination? It would have happened already if it was going to. So the SEP holder goes to a court that can issue that injunction so that it will put them in that power position, again, to get a deal done. So both of those things get a deal done. We've seen it happen in the Panasonic versus Xiaomi, Panasonic versus Oppo. We've seen it happen in other cases, for example, Apple, Ericsson, lots of other cases I can point to where a decision has prompted a settlement and a deal to get done. The question is, what was that decision? Was it a FRAND determination, in which case the party said, well, the court determined the rate and we'll sign on the dotted line, or was it an injunction which then really throws the dynamic out of balance?
Right.
So we have different courts doing different things, which is why the regulation becomes important, because it tries to introduce some consistency in the approach and some consistency in the way decisions are made and what tools are given to the parties to reach that final decision.
Yeah, understood. So it is basically the desire to have a FRAND determination that drives some implementers to the UK recently, if you want, and then of course the race to other courts.
And it's not an immediate thing. I mean, people are engaged in negotiations for a year or two or 3 or 4 years before they get to that point.
Yeah, no, understood. And I mean, I gave you the name ZTE versus Lenovo, and I mean, we know that Lenovo managed to go to the UK and got a FRAND rate there. Now, like, naive question, I mean, what do we do with a UK firm that doesn't have a UK presence? I mean, what happens with those firms? Like like the small firms that have only a continental European presence? What do they do?
Well, obviously, you have to have some standing to go to the UK courts to be able to get a decision there, right? So, I guess if what I'm hearing is true, the UPC can make these determinations, which, I've read a lot about this. I'm not a UPC expert, but I felt like there was maybe some restrictions in the charter and the mandate of the UPC where FRAND determinations were going to be difficult to make. But if there is the ability to make those FRAND determinations and it's only based on what is brought before the court, then I think parties can bring these issues before the court and allow other courts to make these determinations as well. What I'm hearing today, certainly on this panel, is that it's not that the courts are against making FRAND determinations. They have not been presented with the claims and the evidence to make those determinations. So if that evidence is brought, we'll do a test case in Germany, we'll do a test case in the UPC, say, here is my allegation, here's my request to get a FRAND rate set, and see if that's possible in Europe as well. I mean, there's got to be a way to get around this kind of situation of one court helping the parties resolve and determining rates, and another court giving, extraordinary leverage to one party over another.
Yeah. So, before we asked the question whether the UPC is a quantum leap ahead, and we discussed also the methodology that is used there for the FRAND assessment, whatever it means. Now, we have seen quite an influx, actually, in SEP cases at the UPC. I mean, now, like 25% of the UPC infringement actions are SEP cases. That is actually what our assessment tells us. That's a lot, actually. Counts are increasing. What is your read? Are we doing a quantum leap forward by piling more and more of these actions, piling up before the UPC? What does it mean for the SEP regulation?
Well, I think this UPC and the SEP regulation can coexist. You asked that one question about if we do have the SEP regulation and there is a determination of an opinion on aggregate royalty or FRAND rates, that can be brought to the court. That's yet another piece of data that the court can use to make its determination if the parties choose not to settle after they've been given that information through the conciliation process. So having more information out there can only help. It's not going to hurt. It can help because it'll give more data based on which a decision can be made. The problem with the alternative dispute resolution mechanisms, including WIPO, is that it doesn't have the transparency that would allow the parties to do that. When a case is determined, when the parties settle, when even an arbitration award is issued or a mediator makes determinations, that is not available to the rest of the world. And it's fine if we're talking about a regular patent case, but when we're talking about standard essential patents and you have the non-discrimination part of it, it is important to know what others are paying. It is important to know what is that FRAND rate that some independent party, whether it be in a court, we know that. Once the court makes the decision, we see the judge's determination. We don't when there's mediation. We don't when there's arbitration, at least not under the current system. And that's how the SEP regulation is going to be different.
Right.
So they can coexist, and in fact, they could help each other. And one last comment on the regulation is that information that comes out of, for example, a FRAND determination could work for either party. It could be that the parties go before the conciliator and the implementer's offer is way too low, and that FRAND determination could be closer to the demand of the SEP holder. So this preconception that the regulation is only for purposes of lowering rates or only benefits the implementer, I think is completely incorrect.
Okay. Wonderful. Thank you very much. I mean, this is enlightening. Professor Drexl, I mean, thank you so much for your patience. Yes. I mean, you're a co-organizer of this conference. You had the pleasure already to speak at the very beginning. You will have the pleasure also to speak at the very end of this conference. I mean, we are getting to the end. Do you have any views, any immediate views that you want to share with us right now on this panel, or you want to basically do the big wrap-up?
Well, to do the big wrap-up, actually that would be enormously difficult, and time comes to my rescue because time is already up. But let me maybe mention a few aspects. I still think that the attitude to set global royalty rates is a big problem. Because here we actually get into the trap of conflicting judgments. Actually, the question is whether the first court decides the matter, especially where you have full jurisdiction in the UK, where the defendant is domiciled. This may be a res judicata also for the continent, right? And then it's over. This might, in this case, this might simply be the rule of the law, right? So it might be fine. But we also see cases where the basis is simply that the domestic patent was used. And then it is a problem that also before German courts, I saw this in the judgment in the voice age case of the higher regional court in Munich, where at the end they ended up by actually asking the question, what is the security? Mm-hmm. So it's not about friend determination, but the question at the end, stage 5 of the Huawei analysis, what is the appropriate security? And the answer was, it has to be according to global royalty rates, because what you expect under a friend commitment is that you grant a global license, and hence the security that's just mirrored the mirror of it. You have to actually put much more money on the table, and that's the situation we had in China. The Chinese courts also held that based on contract law, you can actually set a global royalty rate, and this only based for the infringement of a patent under Chinese law without global jurisdictions, because both parties came from outside of China. So, and this leads to a clash of jurisdictions. And in the Munich court judgment, I read, so be it. We don't have an international agreement on solving those issues. This is a claim to get things done at the Hague Conference, I would say. We have a problem here. But I think still this is not appropriate administration of justice. So I think also courts should be more restrictive. I have often said we should follow autonomously the principles of the Brussels I regulation. And here, as long as the other party doesn't agree on a global royalty rate, also with regard to the security, I think the same needs to apply. Then be it, we need to accept it. And then, of course, it takes much more time to solve the global dispute. But I think one jurisdiction should not be the court and claim that they are the court for the whole world. And that's the problem. This is why we have a pending dispute before WTO, Europe against China. That is the consequence. And then we only talk about committee. And committee is a rather vague concept. We are now then on the level of general public international law in private litigation, and that's not the appropriate solution, at least not for a long term. That's one aspect that I wanted to bring up. Counterclaims, absolutely fascinating topic. Just an idea. I don't have a conclusive answer. The question still is, the counterclaim is for getting a compulsory license. So I get a license, I go to, I'm sued before the UPC as an implementer, and then I bring a counterclaim, and the question is, what is the legal basis? And there are two possible legal bases. The one is contract law, that's the frank commitment, right? And the other one is competition law. Both might have limitations, because under contract law, I would consider the contract between the SEP holder and ETSI, for example, the standard setting organization, as a pre-contractual obligation, creating a pre-contractual obligation with the duty to negotiate at good faith. This doesn't bring us a concrete royalty rate in principle. I wonder whether we can do this where we already have a friend determination by the EU IPO, because then we could argue that's fair, because what we need under contract law is fairness. This suffices, right? So maybe the courts have more flexibility under contract law. I have my doubts whether we can reach the same result under competition law. Why? The party has, or the implementer has to argue that under competition law, I have a claim to a particular license with particular terms, because otherwise, if you reject this, this would be anti-competitive or not friend. But then I only have a claim to friend royalty rates. So this argues for the upper limit, a higher royalty rate, right? Because under competition law, I can't claim a lower one, right? That's my conclusion, and that's not what serves the implementers. So maybe contract law is the better solution for coming up with a result that does justice to both sides. I don't have an answer at all to the flexibility problem, which was debated before. I don't have an answer. I see both arguments as lawyers who want to actually balance interests. We want to have flexibility. That's very clear. I would also say, and when I read the Commission's amicus curiae letter to the Munich court, this letter doesn't become very precise on step 3 and step 4. I think in steps 3 and 4, we need a lot of flexibility, because in practice, and that's definitely true, this is where negotiations occur and they take time and they go back and forth. So to have such a rigid regime where you only have one shot and then it has to be friend already on the part of the offer by the patent holder, and then also on the other side you only have one shot and this decides the case. That's far away from reality. I see more the value of having a strict regime at the stage of 1 and 2, because that's the starting point for entering into negotiations. And there I think the benefit, because what the Commission also says, and I think this is a particular benefit, and it wasn't mentioned today, at least I can't remember, that this approach of the Commission wants to create a safe harbor for the parties, and especially for the implementers. You cannot be sued if you respect those rules. And I think that has a particular value, because once you can be sued for an injunction, you are basically lost. And at the end, we want to have an agreement, and then it will be at the higher range of friend, right? There can't be any other solution. So that's very tricky. That's not what the Commission actually want, or the Court of Justice wanted to achieve by creating a balance of power between the two parties in a situation where we don't have competition. This is not a competitive market, we shouldn't forget. And also that parties get a particular standard set and then they have a patent in it. That's a decision not by the parties or what they achieved in innovation in a competitive market that was set by a standard setting body. And this is not a unilateral, I would say, a success story of a particular innovator. So I think there are many open questions, and I mentioned a few of them, and I'm looking forward with a lot of interest, I have to say, how the case law will develop. Thank you very much.
Thank you. So join me in thanking this panel here. Wonderful. And more generally, big thanks again to our excellent speakers today. I mean, this was a fantastic conference. I mean, there's lots of food for thought now that we can further discuss at the cocktails that are waiting outside for us. And let me also thank once more our sponsors, Kirkland, Hagen Lovells, and Kamisaska for enabling us to do this event. Thank you so much, and thank you also for you coming.